Yes, I'm very happy. I'm very happy because the reason why I'm happy is because the sole reason why we came to court is because we wanted the court to make a positive declaration that the police, the road safety, that they do not have the right to impose fines on any Nigerian over the motor vehicle insurance. And we have succeeded. We are encouraged in the pronouncement of my Lord Honorable Justice Yelwa, and we sincerely thank the judiciary and the court for this courageous and brave pronouncement today. Efforts were made by the police to arrest the judgment of the court by filing a preliminary objection. They didn't want the court to deliver a judgment, but my Lord Honorable Justice Yelwa was very firm to say that the court will proceed to deliver judgment. And we are happy that Nigerians can now go about their lawful activities all over the country without fear of any imposition of fine by the police, because one of our reasons why we came to court was that we believe that the police, they have a history of extortion all over the country. So we didn't want them to turn the motor vehicle insurance issue into another extortion scheme. So that was one of the major reasons why we came to court, and we are very happy that we have won. Yes, the court ruled against us on the fact that where we had wanted to seek the opinion and view of the court that the police don't even have the right at all to enforce the motor vehicle. But the court disagreed with us and said, yes, by the virtue of Section 4 of the Police Act, that the police have the right, both the police and the road safety have the right to check
the judgment. The judgment of the court, postly put, was partly favorable to the police. However, notwithstanding, we have some issues with the judgment, being that we informed the court of a notice of preliminary objection, challenging the decision of the court to determine this matter. And that issue of objection is based on the jurisdiction of the courts. And the law is settled. We brought to the notice of the court the decision of the Honorable Court of Appeal, Honorable Justice Obando in Adejumo and Agomago, where the court rightly held that jurisdiction is the lifeline, the heart, and the spinal cord of adjudication. And any adjudication without jurisdiction will be inescapably marooned in the intractable vortex of nullity. We brought that before the notice of the court. However, the court went ahead to deliver the judgment. As at now, in as much as the judgment is partly in favor of the police, we envisage that we will likely challenge the proceedings at the Court of Appeal to determine if the court ought to have determined a case where the originating summons, where we are contending that the originating summons is incompetent for several reasons stated in our motion.
I'm the lawyer to the applicant. We had approached the court seeking to interpret the provisions of the National Insurance Reform Act, particularly as it relates to the powers of the police to enforce Third-Party Insurance Act, motor vehicle, and impose fines vis-a-vis the powers of the road safety. It was our opinion that the powers were exclusively domiciled with the road safety and not the police. The court had considered the issues and delivered a well-considered judgment, and she was of the opinion that while the police and the road safety may enforce, they outrightly lack the powers to impose fines on third parties or vehicle owners as it relates to purported enforcement of motor vehicle insurance. And then the court went further to restrain the police, the IGP, the police force, and all their officers, from, including the FRSC, from imposing fines on motor vehicle users or Nigerian citizens in the course of enforcing third-party motor vehicle insurance.